for this afternoon. Thank you, Commissioner Uribe, for bringing that forward. There's some more work needs to be done there to bring some clarity to what it is that we're trying to accomplish. With that, I'm going to go to the next item on our discussion agenda for this afternoon, item D2. Commissioner Bonilla has asked to also do a commissioner's report regarding the Econlockhatchee River Protection Ordinance and to reflect on the right to clean water, charter amendment concerns. And so with that, I'm going to go to Commissioner Bonilla at this time.
Thank you. So the goal of this is that the Orange County Rights to Clean Water Initiative was adopted by 89% of the vote in November of 2020. It recognizes the legal right to clean water and establishes the legal rights of the Wekiva River, Econlockhatchee River, and all other waters of the county to exist, flow, be free from pollution, and maintain a healthy ecosystem. The initiative allows any citizen of the county to bring a legal action in their own name or in the name of the waterways to enforce the rights recognized by the initiative. The initiative has been codified into the Orange County Charter at section 704.1. The current Orange County Municipal Code does not reflect the adoption of the initiative. For day-to-day decision-making on county approvals and permits, the county is not taking into consideration the initiative. To do so, the county must incorporate the provisions of the initiative into the municipal code. Under the current municipal code, the county could be legally liable if the county issues approvals and permits which violates the provisions of the initiative. The initiative specifically provides for liability of governments for violating the initiative. Incorporation of the initiative into the municipal code requires inserting the initiative's provisions into those parts of the code which currently focus on waterways within the county. Because the initiative's focus is on the Econlockhatchee and Wekiva rivers, the first most important places to amend the code are these river protection ordinances. And my goal of this really is to make sure that the voters, the 89% of voters out there who voted on this, that we are recognizing what they want and incorporating what they want. So I understand that there was a Senate bill that has a preemption in one of the sections of that bill. It doesn't cover the entire charter amendment. And actually, the election was after that state law was passed, and there hasn't been any challenges to the initiative's placement on the ballot. So, and also from talking to Jeff Newton, he can clarify more. Well, I read it myself, and it definitely says we cannot give rights to bodies of water or elements of nature. But this charter amendment covers so much more. And just because, and they always put in, if one of these sections are, not, I can't remember the whole legal language, but.
Called the severability clause.
There you go. So we still have the responsibility to make sure that this charter amendment is incorporated. So I am asking the board to have legal look at these amendments and come back to us with some feedback and suggestions similar to what we just did in the previous discussion.
I'm going to ask the county attorney to just kind of update us on what we know at this point and go forward.
Thank you, Mayor. What I will start out with is during the charter review process that culminated in the ballot question that was voted on by the voters in November of 2020. As part of that charter review process and an analysis of the ballot question, the Comptroller provides a financial analysis and impact statement to the Charter Review Commission. In that financial analysis and impact statement, the Comptroller thought it important to comment on the then pending, or I should say, Senate Bill 712, which was at that time had been passed by the legislature but had not been approved by the governor. It has been subsequently, as everyone knows, approved by the governor. And in his financial analysis and impact, he stated that the Florida legislature recently approved Senate Bill 712. That bill appears to preempt the proposed charter amendment and render it unenforceable. As of April 9th, 2020, that bill has not yet been presented to the governor. There was common belief that the legislature was well aware of what the Orange County Charter Review Commission was doing, and therefore passed this particular piece of legislation, not so that it would only apply to Orange County, but would apply to counties and municipalities throughout the state of Florida. I've looked at it. I've had Georgiana Holmes look at it, and other members of my office look at the preemption language. I think that it is quite clear from my perspective with respect to one aspect of the charter, and that's the aspect of the charter which creates natural rights for the waters of Orange County, the right to clean water. I think the legislation itself is pretty clear that it's directly aimed at that in terms of preempting a county or a local government's ability to legislate in that arena. I do believe, however, with respect to the second part of it, it's not as clear, and there may be some question or ambiguities that need to be litigated in order to have a definitive answer. And that second part of it is the part that creates a right of, private right of action to enforce the natural rights. And so it's a very complicated situation that exists. There is currently some pending litigation that was filed, I think about 3 weeks ago, by the, Speak Up Wekiva versus Beachline South Residential LLC, which I understand, and there's some other defendants as well, which I understand is a development which is taking place somewhere in the area of Lake Nona. And one of the questions that will definitely be answered in that litigation, if it proceeds, is the viability of the charter amendment. And because of that, we think, and my office thinks, and I think, that it would be somewhat premature to embed that language of the charter amendment into our ordinances, because it would then place our ordinances at risk of being challenged as well. And it's further complicated by the fact that if we have an ordinance which we are seeking to enforce that has been, in essence, preempted, don't know whether this particular provision of Florida statute applies to charter amendments, but if we have an ordinance that's been preempted and we are seeking to enforce it in some way, and we are involved in litigation, in other words, someone sues us and says that we should not be enforcing that ordinance because it's preempted, that party, if it prevails, is entitled to attorney's fees. And so it just places us in a very exposed condition if we were to move forward at this juncture with respect to amendments to those two ordinances. Now, there may be some things that can be done with respect to those two ordinances to strengthen them, and strengthen them without running afoul of the potential preemption that exists. But that's something that I would leave to staff to try and figure out what to do from that standpoint.
Yeah, so I was going to follow up with a question. So the intent of the charter amendment, can we do something in these ordinances? Like you just said, there may be things that we can do. And the goal is to respect what these 89% of the voters wanted.
There may be some things that you would have to stay as far away as possible from creating rights in natural waters, because that's the specific language of the preemption. But there may be some other things that you can do from a standpoint of amendments to the ordinance that provides the environment with some greater protections. And that's something that staff could research. And I think some staff are present here today that might be able to give you an example or two of what that might be.
I was going to say, give us that opportunity that if the board so chooses, so we can look at it from that perspective. I don't want to put Liz on the spot now. But the answer is we don't know as we sit here right now what those are. But that would require some additional analysis and research for us.
Okay. One thing, if you could look into this, I have a question about the right to clean water. So I know there's no rights for nature, but rights for people to clean water. And don't we already, I thought we already had that right. And so we don't? And humans don't have the right to clean water?
I will tell you that what the legislation, the preemption legislation also says is grant such person or political subdivision any specific rights relating to the natural environment, not otherwise, and this is where there may be an opening, not otherwise authorized in general law or specifically granted in the state constitution. Now, I haven't read every single provision of the state constitution, nor have I read every provision of general law to see whether or not what you're suggesting is an avenue that we might be able to proceed down and not run afoul of the preemption.
Okay. Even under federal law, I thought there's some regulations to make sure that we have clean water to drink.
Yeah, but it may not be a right.
So, I invoked the name of the Comptroller, Phil Diamond, and when I invoked his name, he must have been somewhere watching remotely because he re-entered. And I'll give him the opportunity here in a moment if, I know some rare occasions, but since I invoked his name, he certainly can speak for himself. But part of my concern here is I read the language offered by Commissioner Bonilla. I view it as somewhat broad, and because of the preemption issues, I think that if we have any success at modifying our ordinance without it being challenged, the language needs to be narrow, narrowly tailored, and that is where the county attorney's office comes into play to research. Don't want to expose our board or the county or the taxpayers of this county to litigation and with the unlimited check amount that potentially we will be writing in that case when we know that the pending litigation will likely be resolved at some point in the near future. And so it would be very instructive to us to look at it. And I believe with this whole kind of tone of the times that we're in, where the Florida legislature has focused on preempting local governments from taking certain actions, there will be an opportunity perhaps to collaborate with other counties or local governments at some point to see if there's anything that's running afoul of the Florida Constitution or otherwise. And so again, this is something better to play out within the courts, and we get that instruction, and then we figure out what it is that we need to do, because at this point, I don't think strategically we have a good game plan. So Phil Diamond has indicated a desire to speak since I invoked his name, so I'm going to ask him if he would like to make comment at this time. Comptroller Diamond.
Thank you, Mayor, and you are correct. I was watching remotely. These board meetings really are must-see TV.
Right.
And it's a habit I can't seem to break. That said, I did want to try to put a finer point on what we issued as part of our financial analysis of the charter amendment. And I think, as you all can imagine, when you try to project the cost, it's really hard to figure out the cost. It's a very indeterminate amount, if there is an amount. And I think that's the case here. We didn't think, and I didn't think, that there would be a direct financial impact as far as passing this. I think what we thought is if, and this financial analysis was actually generated before the state took final action on this. We debated at what point to release this, and really the timing of the Charter Review Commission forced us to release it when we didn't know all the facts. But what I can say is I think if the county is involved in litigation over this, yes, there could be an indeterminate negative financial impact to the county. How much would that be? I don't know. I don't think any attorney would ever presume to say what exactly something's going to cost. As far as looking out into the future, if this ultimately was determined by a court to preempt the county, then there'd be no future costs. It would just be a piece of legislation that had no impact. If it wasn't determined to be preempted, then there would be some, there could be some negative consequences. There could be some positive consequences. So I just think it was important for me to add that, to try to put a little bit of color onto our comments. And I would be happy to provide a copy of our financial analysis to anybody that wants it. And I'd be happy to answer any questions anybody might have.
Thank you for sharing. And let me also say this. It will be the desire, I believe, of our board to defend our charter. But at this point, and I would say defend the will of the electorate here. However, I believe that it's premature at this point. I believe that if we let the litigation that's out there move forward and have the courts rule, it may give us an opportunity to be a bit more strategic in what our next steps may be. Obviously, if we, at some point, I can't foretell the future, but if we ever decide to engage in litigation ourselves over this issue, we have to be strategic about it. In the process or the points that we would move forward with, we would have to go into a closed session to have a conversation with our county attorney about what that looks like, et cetera. So I just think that there's a lot that is unknown at this point. And so I would not be supportive of making any amendments or modifications at this time for all of those said reasons. County attorney, I'll look at his body language. He wants to jump in here.
I was just going to say, in order for us to have a closed session, we would have to be, it would have to be pending litigation against the county.
Okay. So, again, a lot of uncertainty there. So, okay, Commissioner Bonilla. So Commissioner Wilson, I know you had pressed your button early on, and some of your concern may have been answered at this point. But I'm going to recognize you if you have any comments.
I appreciate it. I missed a couple of really important family events today to try to make sure I didn't miss this conversation. So I just wanted to reiterate that if there's any opportunity, when there is an express preemption, if there's any opportunity for us to carry out the will of that overwhelming majority of Orange County residents through other, either closing what I've now noticed are strange development loopholes, or otherwise opportunities for us to take action to help protect our water bodies. I think understanding the spirit of that legislation can get us pretty far without putting ourselves in the target of litigation. So I really, really, really appreciate that perspective and encourage that and support that. I think it's important, I know right now this is obviously something that was of great public importance. So people are tuning in, their opponents and their advocates, and I'm glad this needs to be a conversation. But what I want to say to the people that are paying attention right now is you've got to pay attention every 2 weeks, or in this case, every week, because those loopholes I was talking about and the opportunities sometimes that are taken by people who have a vested interest come up, zoom past, and nobody notices. And so we have actually a lot of really pretty great protective language that's already in our ordinances and in our code. I don't know if they're necessarily in the right order or enforced the way they need to be, but I feel like there's a tremendous amount of opportunity for us to take that can move that forward and fall within the clear constitutional mandate that we have to protect the health, safety, and welfare of our citizens. So thank you for the conversation on this.
Okay, Commissioner Bonilla, I'm going to applaud your effort here, but again, I think that it's a little premature, so give us a little bit of time and see how this plays itself out, and I'm sure we will come back and have more conversation going forward. Okay, if everybody's in agreement, that's what we will do. And
Mayor, so I would just like
Commissioner?
to, if we could be kept up to date by email on that litigation, and
We will do that. It's a slow process when it comes to litigation sometimes, but since the action is one where it's seeking to enjoin the defendants from moving forward, I suspect that it may proceed a little quicker than the normal litigation process. So we'll definitely keep the board apprised of that. And as Mr. Brooks has indicated, staff will look at some things that we may be able to accomplish despite the preemption language.
okay. So can we come back again soon to discuss maybe other options that we could do?
I also think that, through our association, the Florida Association of Counties, through our active participation in the association and advocacy, we should endeavor at future meetings to have these types of conversations with our colleagues from the other counties, just to, recalibrate with preemptions and perhaps what counties and or cities may be able to do politically going forward. So with that, I think, Commissioner, you received some feedback today, and the board is as updated as they possibly could be at this point. We will not take any action today on the item. We receive it as information at this time. And looking at the clock, the next public hearing begins at 5:01, so we will go into recess until just before 5:01, and we will reconvene at that time for the final public hearing of the day. Okay?